Thank you for joining us for the enforcement workshop. The target audience for this presentation are licensed registered nurses in the state of California. I'm Shannon Johnson, the Deputy Chief of Enforcement responsible for discipline, probation, and the intervention program at the board, and I will be one of your presenters today.
And I am Joseph Pacheco, Deputy Chief of Enforcement responsible for complaint intake and investigation programs at the board, and I will also be one of your presenters today. This live presentation is being recorded with the intention of making the recording available on our website in the very near future.
Questions during the presentation are being accepted via email, so please send questions to the email address webcast.brn@dca.ca.gov, and we'll try to address as many questions as we can at the end of the presentation. However, all questions and answers will be posted to our website at rn.ca.gov with the recording of this presentation. Keep in mind that this email address is only valid during this live presentation. The learning objectives are to explore the enforcement program and what constitutes a violation of the Nursing Practice Act, review complaint intake and investigative processes, describe the forms of discipline that can be imposed on a license, and define the intervention program and how it differs from the probation program. Today, we will be covering the complaint intake unit, investigative unit, intervention program, citation unit, the discipline unit, and our probation program.
The complaint intake unit performs all initial processes for all BRN enforcement cases at the board. The BRN relies heavily on outside sources to alert us of potential issues with a licensee. Complaints are received from several sources, including notification from the Department of Justice or the FBI that an RN has been arrested or the nurse has received a criminal conviction. All RNs in the state of California are fingerprinted prior to licensure. And many of the RNs listening, their fingerprint data was updated within the last 3 years when they renewed their licenses. When an RN licensee is arrested and booked into a county jail in California, the BRN is notified by the Department of Justice the very next day. The board is also made aware of any discipline by other state licensing agencies. The Board of Registered Nursing is a member of the National Council of State Boards of Nursing, and we share data to the National Council's Nurses database. When a license is disciplined, and that information is added to the nurses database, all other states where the RN is licensed are notified of the discipline order. Having a license disciplined in another state is grounds for action on a California license under California law. And we also receive public complaints alleging unprofessional conduct, gross negligence, and/or incompetence. Any complaint received must allege an act that, if proven, would be a cause for discipline. Any complaints that do not represent a violation of the Nursing Practice Act are closed without action. Within our public protection mission, the BRN is authorized by law to investigate and take disciplinary action only on specific issues. These issues include, but they're not limited to, the following: license application fraud or misrepresentation. For example, falsified transcripts or other falsified credentials used to obtain a license in California. Substance abuse. Nurses must know that evidence of substance abuse, whether at work or in the RN's personal life, may be grounds for discipline of their license. Any mental health or mental illness issues that affect the RN's ability to practice safely. Any unlicensed activity. The public usually does not know that the use of the title RN without a valid license is a crime in the state of California. And any earnings that an imposter RN earns while illegally working as an RN is considered theft, and when proven, often result in felony charges against the individual. Gross negligence or incompetence allegations are almost exclusively related to the direct patient care and nursing practice issues. Gross negligence is defined in our regulations as an extreme departure from the standard of practice. An extreme departure means the repeated failure to provide the required nursing care, and it can also mean the failure to provide care or exercise precaution in a single situation which the nurse knew or should have known could result in patient harm or death. Incompetence is defined by our regulations as the lack of knowledge or skill in discharging professional obligations as an RN. Other unprofessional conduct can be a cause for discipline as well, and some examples of this would be convictions of a crime. Those are considered unprofessional conduct. Nurse-patient boundary issues and HIPAA violations are some of our more common issues we see at the board. Now, the small print at the bottom of this slide contains references to both the laws and the regulations guiding BRN's evaluation of complaints and our subsequent action after an investigation. The BRN does accept complaints by mail, email, and other means, but it's highly recommended that all complaints be submitted online through the BRN's website. Follow the enforcement links on our website at rn.ca.gov to submit a complaint against a licensee. The board does accept anonymous complaints. However, without a complainant to ask follow-up and clarifying questions, the anonymous complaint must be specific regarding the dates, times, and the location of the incident. Anonymous complaints should include the names and contact information of all direct witnesses so that an investigator can properly follow up. And it's also important to note that anyone can submit a complaint to the BRN. We receive complaints from consumers, patients, patient families, employers, coworkers, general members of the public. We also receive cross-referrals from other state or government agencies, and we often receive contact from local law enforcement agencies.
The board has available to California nurses an intervention program. January 1st, 1985, the BRN diversion program was signed into law. The board has since changed the name to the intervention program. And the intervention program is a voluntary and completely confidential program for licensees who suffer from substance abuse and/or mental illness. As a licensee, all complaints that the board receives involving drugs, alcohol, or mental illness will get an offer letter from the program inviting them to participate. If it was a patient care issue as well, the board will continue with an investigation while you are going through the program. The board will not take action against your license if you complete the program successfully. However, if you don't complete the program successfully and you leave for any reason, the board will continue with the disciplinary proceedings against your license. The board has two types of referrals. There's a board referral, which is based upon an initiated complaint involving drugs, alcohol, or mental illness. You may also self-refer into the program. This is when the RN contacts the board without having a complaint filed against their license. In order to enter the program, you will need to meet eligibility requirements. You must have a valid and current license residing in California. You must meet the criteria of being substance abusing and/or mentally ill, and you must agree to all the contract terms. You will not be deemed eligible if you've had a previous discipline for substance abuse or mental illness, if you've been previously terminated from the program, or if you've sold drugs or caused any patient harm. If you agree to enter into our intervention program, you'll have an intake call within 10 days. You will need to voluntarily inactivate your license. There will be a clinical assessment within 30 days, and during this time, you will be having weekly communication with your assigned case manager. You'll also meet with your intervention evaluation committee, And this is where you will be found eligible for the program and what your individualized treatment plan will be. Your treatment plan may include a rehabilitative program that can include inpatient care followed by intensive outpatient care, attending 12-step programs as needed. And when you initially enter the program, you will be required to complete 90 meetings in 90 days. Monthly self-reports. You'll be required to attend nurse support groups at least once per week. You'll be required to submit to random drug and alcohol testing, and this may include urine, blood, hair, and nail testing. Gradually, we will return you to work. Participants are returned to work under supervision and monitoring as soon as they are deemed safe to practice, and the amount of supervision and frequency of testing is gradually then reduced. The board currently has 14 intervention evaluation committees across the state that are comprised of 3 registered nurses, 1 physician, and 1 public member, and they meet quarterly, no more than 30 participants per committee. All of these members must be experienced in the treatment of chemical dependency or mental illness. If you're interested in being an IEC member, each member must have an expertise in the field of substance use and or mental illness, able to commit to a minimum of 4 days per year for meetings, and be willing to take on the responsibility of deciding eligibility and creating a rehabilitative plan. And for more information on becoming an IEC member, visit our website at rn.ca.gov and click on the Intervention tab. Participation in a nurse support group is a requirement for nurses in the BRN's intervention program, and we have approximately 50 groups across the state of California that have assigned facilitators and co-facilitators. Each group has no more than 15 participants. And if an RN is unable to pay, fees will not be a barrier for participation. If you're interested in becoming a nurse support group facilitator and you meet the criteria, go to the BRN website and click on the Intervention tab to read more about how you can begin giving back to your nursing community. Our intervention and probationary nurses are probably some of the most diligent and safe nurses you could have on staff. These nurses are monitored by worksite monitors. They must stay completely compliant with the board's programs, and those with random drug testing have proven record of sobriety. They also must maintain a higher level standard of care. So if you are an employer that would like to learn more about employing our intervention or probationary nurses, please contact the board at enforcement.brn@dca.ca.gov for more information. And for more information on our intervention program, you can also visit our website at rn.ca.gov under the Intervention tab. Again, during this presentation, please send your questions via email to webcast.brn@dca.ca.gov, and we'll answer questions at the end of the presentation. Remember, this email address is only valid during this live presentation.
Any complaint requiring the board to gather additional information is referred for an investigation. We investigate all subsequent arrests by BRN staff when a nurse is arrested for a crime. We obtain law enforcement, investigative, and arrest records. We'll get the arresting officer's written report, and in some instances, the board will obtain officer body camera and audio recordings of the arrest. We obtain court records. We look for the final conviction and what exact law the RN was convicted of. After all of the evidence is collected on our subsequent arrest cases, board staff will make a recommendation for board action. And the potential actions in these cases are to take no action, issue a citation, or refer the case for formal disciplinary action. In 2018, the board investigated 1,456 subsequent arrest and conviction cases. For egregious issues, in the criminal realm, the board has the authority to appear before a criminal judge and request that conditions be placed on the license as a condition of bail. The board takes these emergency actions only in the most egregious criminal acts, such as rape, murder, attempted murder, crimes involving children or the elderly, lewd and lascivious acts, and assault with a deadly weapon. If the judge places conditions on the license, usually a suspension of practice, the order is immediately posted on the board's website and NERCY's. This order will be in effect until the criminal proceedings have concluded. Luckily, these issues are very rare, but the board does receive a subsequent arrest that meets these criteria on average of once per week. Complaints alleging incompetence and gross negligence have to be sent to a field investigation. Any allegation where additional information is required or witnesses to be interviewed will be sent for a field investigation. And depending on the severity of the complaint, investigations may be conducted by one of two investigation units. The BRN has its own in-house investigation unit consisting of non-sworn special investigators. Our in-house unit conducts the investigations on most of our practice and patient care complaints. And the Department of Consumer Affairs has a sworn peace officer division called the Division of Investigation, and DCA sworn law enforcement investigators investigate the board's most egregious complaints, including the criminal statutes within the Nursing Practice Act. Investigators will collect all patient care records, facility training records, evidence of the RN's specialized training and certifications, as well as personnel records. Other evidence, including video footage at the facility, audio recordings, business documents, will all be obtained as needed, and all witnesses will be interviewed. So what are the common complaints resulting in the investigation of an RN's license? First and foremost, substance abuse. DUIs, whether a single DUI or multiple DUIs, are one of the more common criminal statutes that the board deals with in our workload. And there are several reasons why the BRN considers convictions of a DUI when considering disciplinary action against a nurse. Some of those reasons: first, RNs work in critical, life-threatening situations where patient care decision-making can be seriously compromised while under the influence. Two, if an applicant is willing to get intoxicated and risk public safety by getting behind the wheel of what is essentially a deadly weapon, the BRN will consider the risks of similar behavior in a patient care setting. And three, the California Supreme Court has ruled on this matter, and the ruling was that DUI convictions are substantially related to the practice of a healthcare license. The board will look into narcotics diversion, whether at work or outside of work. Any arrests or convictions for the possession of controlled substances without a valid prescription. I think it's important for nurses to note that it's arrests or convictions. The board does sometimes file actions against a nurse's license, even if criminal charges are not filed. If criminal charges aren't filed, the Nursing Practice Act allows administrative action based on the behavior alone. Use of a controlled substance, prescription medication, or alcohol in a manner injurious to the RN or others is grounds for action under Business and Professions Code Section 2762, Section B. And the board also looks at allegations of intoxication on the job. Dishonesty. That would include theft, fraud, shoplifting. Most of the crimes are acts that we usually associate with dishonesty, but it can also be specific work behavior, pre-charting criminal assessments before the assessment is actually completed, changing charting or attempting to cover up after a mistake on the job is made, and falsifying a medical record, which is a crime in the state of California. And when nurses falsify a medical record for their own personal or financial gain, the discipline is much more severe. And then there's behavior that causes or risks harm or death to a patient. Egregious or repeated medication administration errors, not advocating for patient safety, failure to follow infection control guidelines, providing medications to coworkers or friends, patient abandonment. It's important for nurses to know patient abandonment can only occur after a nurse has taken on the care of the patient. We frequently receive complaints from employers and supervisors that the nurse quit unexpectedly and did not show up for work one day. That is not patient abandonment. And then there's communication failures. Refusal or inability or forgetfulness of giving handoff reports on patients. This has the potential to cause a patient safety issue. In our experience, these communication failures are almost always wrapped around some interpersonal conflict at the worksite.
Violations that don't rise to the level of formal discipline may receive a citation. Citations are an administrative action and are violations that don't rise to the level of formal discipline. They may include a fine up to $5,000 and also may have an order of abatement. Examples of the types of citations that are issued are normally for first-time convictions such as petty theft, out-of-state disciplines on other than nursing licenses, non-compliance with the board's fingerprint requirements, failure to update your address of record, and finally, unlicensed practice. Other than criminal prosecution, this is the only action the board has authority to take against unlicensed practice. There are exceptions to citations being issued that are the violation is of such severity that revocation of the license or restriction of the license is necessary. And this includes physical abuse, neglect, abandonment, fiduciary abuse, or deprivation of care or services which are necessary to avoid physical harm or mental suffering. A citation will be issued in writing and will describe the nature and facts of each violation and may contain an assessment of administrative fine. There are, however, appeal rights to a citation. The citation will advise the RN of their rights to an informal citation conference and the right to an administrative hearing. Should you choose the informal citation conference, a time and date will be set up for you to address any mitigation you would like the board to take into consideration when making a determination on either to dismiss, modify, or uphold the citation that was issued. Once the informal conference decision has been made, you have 30 calendar days to request a formal hearing. The formal hearing request is sent to the Attorney General's office so they can get the hearing on calendar with the Office of Administrative Hearings, and your case will then be heard by an administrative law judge who will have a proposed decision to the board within 30 days of that hearing date. And the board will vote whether to accept or reject the decision of the administrative law judge. You may also skip the informal citation conference and request moving straight to a formal hearing. Once the citation becomes final, it is a non-published public record. Your citation will be purged 3 years from the date of resolution, meaning that the fine has been paid in full. If the outcome of your citation resulted in a dismissal, your information will be purged no more than 1 year from the date of resolution. Should you not comply with the citation, the board will begin further action. You will receive 3 notices, The first two are letting you know that your fine hasn't been paid. The third notice is informing you that the amount has been sent to the Franchise Tax Board for collection. Should you not pay your fine in full by your next renewal cycle, you will not be able to renew your license. And disciplinary action may also be taken by the board. If your violation rises to a higher level, then the board will pursue formal discipline against your license. Once the case is received from complaint intake, it is prepared by the discipline unit and transmitted to the Attorney General's office. They will prepare an accusation, which will be served to you via certified mail. If an accusation is not immediately filed, the board may choose to order you to compel to a psych or physical exam. Once you receive the accusation, you will have 15 days to file a notice of defense. This is appealing your accusation. When it appears that you are unable to practice, or when your practice is impaired due to a mental or physical illness, the board may order the RN to be examined. This exam may be used as evidence in proceedings conducted if the RN is found to be unsafe. And the board may revoke, suspend, place on probation, or other action deemed proper in the board's discretion. A stipulated settlement is an agreement between the board and a licensee. You, as a licensee, are permitted to submit any mitigation that you would like the board to take into account when considering a possible settlement. And you may also have legal representation, but it is not mandatory. You may not agree with the board's settlement and choose to proceed to a hearing. If this is the case, the Deputy Attorney General will set a hearing with the Office of Administrative Hearings, and the Administrative Law Judge will hear your case. Again, you can choose to have legal representation, but it is not mandatory. The Administrative Law Judge will provide the board with a proposed decision within 30 days of the hearing date. There are a few possible outcomes to the case. A public reproval is the lowest form of formal discipline. You may be given a license on a probationary term. Or your case could end in revocation by not providing a notice of defense to the board appealing the accusation. If the proposed decision by the ALJ is revocation, or if you fail to appear at the hearing. And all orders are sent to the board, and they have final vote on all decisions. The board and the administrative law judges utilize the board's disciplinary guidelines when determining settlements. These guidelines have been put in place.
2008 fiscal year marked the highest of applicant and workload in the BRN's history. Those complaints, the disciplinary actions, and the number on this slide. If we take approvals, probationary orders, surrender decisions, and revocations of licenses, altogether that represented 1,993 disciplinary orders by the board. And this represents less than 0.5% of all licensees. And if we go on to advanced practice nurses, the discipline is even more rare. So with nurse practitioners, just over 0.1% of all nurse practitioners received some disciplinary action. And for nurse midwives, it was 0.2%.
Let's take a look at probation. Probation's program role is to ensure consumer protection through the monitoring of nurses that have been placed on probation. We enforce the compliance as outlined in our disciplinary guidelines, and we provide the probationer the tools to be successful, and we take additional disciplinary action if necessary when a violation of the conditions of probation or there is a subsequent violation of the Nursing Practice Act. Violations may be sent back to the Attorney General's office for further action against the license. All cases on probation will receive standard conditions of probation, which could be obey all laws, comply with the program, reporting residency, submitting reports, work, and all employment must be approved by the board prior to continuing employment. Supervision levels, completing nursing courses, and cost recovery. If your incident was based on a drug, alcohol, or mental health issue, then you will more than likely be given these optional conditions. When I say optional, it is an option for the board to impose them. They may include an AA, NA, or any other 12-step program, treatment, therapy, nurse support group, abstaining from any mood-altering drugs, and testing. A suspension of license may be imposed to ensure public safety. It could be for a specific amount of time or until required physical or mental examinations are completed to ensure that the RN is safe to practice. Here's a look at the difference between intervention and probation. The two are very similar, however, there are a couple differences that I want to point out. So your initial intake assessment, one is conducted by your clinical case manager, the other is by a probation monitor that's assigned to your case. The clinical assessment is paid for through the intervention program. It is an out-of-pocket expense for a probationer and could be quite costly. They both have treatment plans. They both need to comply with drug testing. They both need to attend nurse support groups and 12-step programs. There is an administrative fee of $25 for an intervention participant. There is no cost as far as an administrative cost to the RN on probation. However, cost recovery is ordered pursuant to Business and Professions Code 125.3 for all of the investigative and enforcement costs during the time of that case. Two very important points is the intervention program is completely confidential. The probation program is not. It will be posted to nurses and it will be posted to the BRN's website for 10 years. However, even after that, it is still a public document. The intervention program is not considered discipline. It is an alternative to discipline program. The probation program is a formal disciplinary action and will remain on your record. So those are 2 points to be cognizant of when you're looking at whether or not you want to enter our intervention program or proceed down the path of formal disciplinary action. For more information on the enforcement process, you can visit our website at www.rn.ca.gov. Click on either the Enforcement tab or the Intervention tab to get more information on reporting, documentation requirements during your process of disciplinary action. We want to thank you for your time today. If you have questions to be answered for this webcast, again, send them to webcast.brn@dca.ca.gov. Should you have any other questions, here is the enforcement contact email address, and you can find more enforcement information at our website. And we will now move into the question and answer portion of the presentation.
So 2 of our managers, Timothy Bunger, our manager of our discipline unit, and Sonia Wilson, manager of our complaint intake unit, have been receiving the questions through email, and they have been curating these questions, and they will be asking them for us to answer. Which of you will go first?
I guess I'll go ahead and start. First question we got is, can a nurse manager's license be disciplined for refusing requests for adequate staff for safe patient care?
Our law is pretty specific, not law, our regulations are pretty specific regarding nurse supervision. Supervisors are required, just like staff RNs, to advocate for patient safety. So they have a duty and an obligation to ensure patient safety, and they also specifically have a duty to assign nursing work only to people who are competent to perform that work. So we do receive complaints on nurse managers. Of course, facility policies and procedures come into play, as well as laws and regulations put forth by the California Department of Public Health. But to answer the question, yes. Yes, they are.
Will slides be available to view? And what are the business and professions codes or any additional codes for the slides, such as grounds for disciplinary action?
This presentation will be recorded and it will be posted to our website within the next couple weeks. The code sections will be available that determine what the grounds for discipline are.
Yeah, they were contained in one of the slides. I think we put in business and professions codes 820, 2761, 2762, and then our intervention codes were on there as well. And yes, that'll all be posted, as well as the answer to this specific question.
Does probation require you to deactivate your license? If not, isn't that a difference between probation and intervention?
That is currently a difference between intervention and probation. Intervention does require you to inactivate your license, and in probation, you are not required to inactivate your license unless we have a suspension placed on the license prior to, which in some cases, when we do feel that there is public safety risk out there, we will put the suspension, which I showed in one of the probationary slides as a condition of probation. We will apply the suspension of licensure usually until they have their mental and physical assessments to ensure they're safe to practice.
How many RNs are currently on probation in California, and how many are in intervention?
Currently on probation, we have, I believe it's a little over 1,200 right now, and there's about 400 plus that reside outside of the state of California. In the intervention program, we have just under 400.
If a registered nurse self-reports to the intervention program via the 800 number, are they required to contact the BRN as well?
No, they are not. If they contact intervention program through the 800 number, they will go to our contractor, and the contractor will set them up for entering the intervention program.
If a nurse is placed into therapy as a condition of probation, does the therapist provide reports of those meetings to the probation unit? If so, doesn't that impact the confidential nature of therapy, which is one of the benefits of therapy?
There is a compliance or a condition for compliance with therapy that they must attend. Probation unit can require reports on any of the conditions as far as employment, as far as treatment, therapy, testing. That is the probation's program is to ensure that they are compliant with all of those conditions. So yes, reporting is required and will be provided to the probation monitor assigned to the case by the therapist or the assessors.
What is the process for early termination for probation?
If you are on probation and you have been completely compliant with your probationary terms, you can petition the board for early termination of probation after 2 years. At that point, you would contact your probation monitor to follow that process.
What efforts are being made by the BRN to ensure nurses on probation can work as nurses? What is the BRN doing to rectify when facilities are firing nurses that are placed on probation?
This is a big question that's come up in a lot of forums when we talk about nurses that are being disciplined, whether they're on probation or intervention, and whether or not they're able to find employment or maintain employment. I won't, say that it's easy. It's not going to be easy. However, we recently looked into some numbers of current probationary nurses that are non-compliant with the employment condition. And out of the 1,200 plus nurses we currently have on probation, there were 11 nurses that were not compliant. So our nurses are finding employment. As you'll notice in one of the slides that we put in here today, we would like to start working with some facilities to try and employ these nurses to make it easier for them out there. And we hope that we get some feedback or some communication with some of these facilities, and we can assist these nurses in finding employment easier.
Is there a specific start and end date to intervention, similar to the way it is in probation?
Intervention, when you go to your intervention evaluation committee, they will determine what your individualized plan is. It could be 3 years, it could be 5 years. It depends on how you follow through that process. If you relapse or not, that could extend your time in the intervention program. So it really depends on you as a participant and your compliancy with the program.
If a self-reporting registered nurse plans on retiring within 12 months, what options do they have for entering the intervention program?
You can enter the intervention program as long as you have a valid license. You can retire and still maintain a valid license, so the program is still available to you.
A nurse with a complaint against them, though, there is a time limit there. Once that enforcement case, when the investigation is complete and an accusation has been issued to against the license, at that point, intervention is no longer an option for that nurse. The board will go forward with disciplinary action. I should say the protection against discipline no longer exists. The nurse can still go in and participate in the program, but the board will continue with the disciplinary action at that point.
What are the processing times to early termination, approximately? And what are the chances of the board approving volunteer work as a second job?
Volunteer work is considered for the employment compliancy for the condition in probation, as long as it is 24 hours per week for 6 consecutive months. They fulfill, that is the condition of probation that they must fulfill. And I'm sorry, can you repeat the first part of that question?
What are the processing times to early termination?
For early termination, the processing times used to be quite lengthy. Within the last year and a half, we have changed our processing of early terminations of probation. And I believe within just a month or two, now we've got it down from about 10 months down to, I want to say roughly about 2 months now. Within 2 months, you could be granted your early termination of probation through a stipulated settlement as opposed to going before the board to review your case. And those are for the cases that are completely compliant with their probationary conditions.
You mentioned that the nurse did not have to be represented by legal counsel during the accusation process. Is the board represented by legal counsel during the accusation process?
Yes, the board is always represented by the Attorney General's office, and a Deputy Attorney General is assigned to each case.
If an RN enrolls in the intervention program, but they are not permitted to practice, how do they support their family?
Substance abuse and mental illness is considered a disability now. There are options out there to have income coming in while they're in the program, and that will be discussed with their case manager when they enter the program.
We're just waiting on more questions to come through.
Well, if there are additional questions, we invite our participants to email the Enforcement Division's email address at enforcement.brn@dca.ca.gov. Just a reminder, the webcast email address will no longer be valid after the end of this presentation. And if we don't have any more questions, this will conclude our broadcast for today. We want to thank everyone for tuning in. And as a pitch, Shannon and I do have a roadshow for hospitals and nursing associations and schools. And we will come out to a facility to give either your members or staff a presentation on our enforcement division. We want to get the word out about our division, what we do, how we do it. If you are interested, please email our enforcement division email. Thank you for tuning in today, and this concludes our presentation.